Okay, so welcome to tonight's session. We're going to look at the level 2 business environment unit, sometimes known as BESY, and we're going to look at the topic of contract law, which is one of the many areas that are covered by this particular unit. So we've got an hour. So I'm going to try and make it a little bit interactive along the way. It's a little bit of interaction from yourselves. So what are we going to cover? Well, hopefully explain the look at these 5 sort of key learning objectives, if you like, or outcomes from today. So look at the essential elements of a contract. So explain the 5 core components of a valid contract. Talk a little bit about this concept of an agreement. So master the mechanics of an offer versus an invitation to treat, and try to just clarify exactly what is an offer, what is an invitation to treat, so we don't, when we come to answer questions in the exam, become confused about whether we've made an offer or received an offer, or whether it's just an invitation to treat. And I'll explain a little bit more about those terms as we go through it. Talk a little bit about consideration, so understand what constitutes a valid price in inverted commas from a legal perspective. Look at what happens if we have a breach of contract and this concept of damages. So identify how contracts can end and what to do if things go wrong. And then off the back of that, look at some potential remedies. So mentioned one, damages, but also look at other equitable remedies with a couple of scenarios that we've got around how we might remedy potential breach of contract. So, without further ado, foundations of a contract. So what is it that we need that makes a contract? So first thing we need is what's known as an agreement, which is made up of an offer and then acceptance. So an agreement essentially is a meeting of minds. So it is someone offers something, a clear offer is made, and then we get what's known as unconditional acceptance to that offer. So if we think about, if I wanted to sell my car, I could say to someone, I'll offer to sell you my car for £20,000. And someone could then accept the terms of my offer, which is, you need to give me £20,000 and I want the money by the end of the week. Yeah, so I've made a very clear offer. And then someone has accepted it unconditionally based on the offer that's been made. Second part of a contract, another key element of a contract, is this thing called consideration. Now, big problem I have when I teach level 2 is people they think that consideration means cash. Now, whilst it does in most cases, it doesn't need to. Yeah. So, mentioned on the slide, it's the price, in inverted commas, that is paid. Does not necessarily mean cash. So I could, for example, make an offer to sell my business in exchange for shares in your business. Yeah, so I could, and that's generally how lots of business takeovers happen. So you can buy shares in my company in exchange for shares in yours. Yeah. In those cases, there is no actual cash changing hands. Yeah. Considerations can be other assets, don't necessarily need to be physical cash. However, it must have a value, but does not need to be a fair market price. We'll touch on that again in a little while. You must be able to value the consideration. It doesn't have to be a fair market price for what you're essentially purchasing. The third really key element is that you can't enter a contract unless you have capacity to do so. So are the parties to the contract legally able to put themselves in a position where they are in a contract? So think about minors, so people under the age of 18. There's laws in the UK saying people under the age of 18 can't take on debt. So you can't have a credit card if you're under 18. Also, there's laws that say that you can't enter a contract if you are of unsound mind. So if you're mentally incapacitated in any way, you don't have mental capacity to enter a contract. Put something there around intoxication. Well, arguably, if you're intoxicated through drink or drugs or a combination of both, you don't have capacity, and therefore you legally don't have capacity to enter a valid contract. And then, of course, you could have an agreement with an offer, acceptance, consideration could have been given. You could have capacity, but what is the contents of the contract legal? So courts will not enforce contracts for illegal acts. Yeah, so any form of crime or public policy breaches. So, for example, if you had a contract, crazy example, but if you had a contract that said that I'm going to contract you to go and rob a shop, well, it's not a legal contract, is it? Because that's commit a crime. That's very much not a legal contract. Okay. Example then. So we move on to look at some of this, break some of this down in a little bit more detail. So an offer. Yeah. So what is an offer? An offer is a definitive promise. A definitive promise to be bound on some specific terms. Now, pulled out some examples, and these are real-world examples of some different case studies. So there's a company, this one, Carlyle, 1893. Yeah, I appreciate it's a little while ago. So in this case, there was Mrs. Carlyle and this company called Carbolic Smoke Ball. The company offered £100. Now, can you imagine how much £100 was in 1893? About £17,000, I think, inflation adjusted. Yeah, to anyone who caught flu after using their product. Yeah. So they were so sure that their product works that they said, well, if you catch flu after using our product, we'll give you £100. So Mrs. Carlyle did get flu, and the court ruled that the advert was a valid offer to the whole world. Yeah. Carbolic Smoke Ball were trying to argue it wasn't a valid offer, and therefore they didn't have to pay any damages. The courts said, well, that advert was a valid offer. It was made to the whole world. She accepted it. Both parties accepted there was an agreement, and both sides were bound on the terms of that offer, and therefore damages were awarded in this case. The key takeaway there is an offer can be made to one single person. So I could offer to sell my car to a particular person. It could be to a group of people. So I could sit in the pub and say, I want to sell my car. Here's the price. Who's interested? Or I could put it on eBay. Yeah, if put it on eBay, that's the entire world, making an offer to the whole world. Yeah, so it does not need to be just one person. It can be a group of people. It can be the whole world or a subset of that. Now, one thing that we see when we talk about this in classrooms, when I and the team here talk about it in classrooms, is that students get confused about the difference between an offer and this thing called an invitation to treat. So I got some examples just up on the slide there around some key places that you see offers or invitations to treat being presented. So shop displays. So goods in windows or on shelves in supermarkets. Yeah, so you walk past, I don't know, Primark, and you see some display in the window. Yeah, and it's got some price at the bottom saying you can buy this T-shirt for £2 or whatever. Yeah, or you go to Tesco's and there's a load of stuff on the shelf. Yeah, is that an offer or is that an invitation to treat? So some people think that, well, that's Tesco's offering to sell it to me. Now I can see the logic, but actually legally it's an invitation to treat. The customer makes an offer to buy those products when they take them to the till. Yeah, so while all the time it's on the shelf, it's an invitation to treat. It's not an offer. Yeah, customer makes the offer when they take it to the till. They offer to pay whatever it is that the shop is wanting for those goods. They offer to pay that at the till. Adverts, very much the same thing. Generally, invitation to treat. They only become offers if they are highly specific. A bit like the example on the previous slide, which is highly specific. I'll give you £100 if you catch flu. Very specific. And then the final element are these things called tenders. So tenders is ask you, a business or a consumer, asking for bids to provide some service or some goods. The person that submits the bid is making an offer. Yeah? So we the company are saying, for example, we want some tenders to paint our office. Yeah, so decorate our office. So we go to the local decorators and we say, this is what we want. We want all the walls painting lime green. How much? And then we offered, and then they all make us an offer. Yeah, so they submit a bid, which is an offer to us. Yeah, so just the difference between offers and invitations to treat. So what I got on the next slide then is just a couple of examples of identifying the legal status of different scenarios. So we've got a price tag on a dress in a shop window. Yep, so dress is in shop window, on a mannequin in shop window, and it's got a price tag on it. Yep. So you can look up the various pieces of law. I will provide the links to these case studies. But a price tag on a dress in a shop window is legally been tested to be an invitation to treat and not an offer. Yeah. The offer's made when I take the dress to the till and offer to buy it. That's the point the offer's made. A company prospectus for shares. So this is me saying, the company saying, you want to buy some shares, and here's all the information about it. Again, it's an invitation to treat. The offer's made when I essentially say, yes, I'll buy them. Yep, that's the point at which I make an offer. I'll make an offer to buy X number of shares at a given price. A reward of £50 for my lost dog. Very much an offer. That's somebody making you an offer to give you £50 in exchange for their lost dog. That is a unilateral contract. It is an offer, very much. Yeah. The bottom one is most definitely not an offer. I might, well, you may or you may not, sell my car for about £5,000. Well, is that 5,000, 5.5, or 4.5? Too vague. Yeah. It's a vague statement. Ultimately, it's supplying some level of information. There'd be some back and forth, wouldn't there? There. So if I said that to a friend in the pub, I might sell my car to you for about 5,000. The questions I'm going to get back is, well, is it 5,000 or do you want 5,500? Yeah. So we'd enter into that supply of information chain where I supply some information, they ask some questions, until we get to a point where somebody does make an actual offer. So once you've made an offer then, an offer can be terminated. Yeah, so I could make an offer today to say, I'll sell my car for £20,000. Yeah. The offer, that offer ends when it's no longer capable of being accepted. And that could be for any one of these 4 reasons. So I could withdraw my offer. So I could say, I'm prepared to sell my car for £20,000 because I don't need it anymore. And then tomorrow, my circumstances could change and I do still need my car. So I could just revoke the offer, so withdraw the offer before acceptance. So before you accept the offer, I could just say, I've changed my mind, decided don't want to sell my car anymore. We could get rejection to the offer. So I could offer to sell my house, for example, for £250,000, and somebody could say, no, I'm not, I don't want to buy it. Or somebody could make me an offer to buy the house for £250,000, and I could say, no, not enough. Yeah. So rejection is just explicitly saying no, absolutely not a chance. Another way we can terminate an offer is through what's known as a counter offer. So I make an offer, and then someone counters that offer with a different offer. By doing that, the initial offer is terminated. Yeah. So if I make an offer, let's say I offer to sell my house for £250,000 to someone, and they say no, but I tell you what, I'll buy it for £200,000. That initial offer now no longer exists, and there's a new offer back to me. Will you sell it for £200,000? Yeah. So it rejects the initial offer and replaces it with a new offer. It's a piece of case law there that goes into that in a little bit more detail. And then the final way that offers can end is through this concept of a lapse of time. Now, some offers will very much have a deadline attached to them. So my offer is this, you need to let me know by Friday. Very much a very hard deadline. You must let me know by Friday. If you don't give a hard deadline, it's just what's considered to be a reasonable amount of time. Now, reasonable is a bit grey in some ways, isn't it? Yeah. If I was to sell my mobile phone for £200, a reasonable amount of time for someone to make a decision about buying a phone for £200 is very different from a reasonable amount of time for someone to decide to buy a house for £300,000. They are different levels of financial transaction, and reasonable amount of time to think about that is very different. But it's just about what the average person would consider a reasonable amount of time. No sort of hard and fast rules there. So once you've made the offer, then the offer can then hopefully at some point be accepted. So you might go back and forth through that counter offer, but at some point, hopefully, you're going to get someone say, "Yep, I'll accept that." And that's the process of acceptance of an offer. So what acceptance gives you is unconditional assent to the terms of the offer. So acceptance must be to all terms, and any change to the terms makes it a counter offer, which kills the original offer, which is what we've said before. So you must agree all terms of the offer. If you don't agree all terms, you're ultimately saying, I don't agree to all of that, but this is what I do agree to, and this is what I am prepared to accept based on, which is a counter offer. Acceptance of an offer must be communicated. Yeah. So the most important thing to remember there is silence does not presume acceptance. So if I say nothing, you can't assume that I've accepted the terms of the contract or the terms of the offer. Yeah. So I very much do need to communicate it. Silence means I've not accepted. In terms of communication method, then it can be orally, written, which are fairly easy to understand, so I can tell you, and I can write you an email, letter, fax, some form of written communication. Now, again, it depends on the context, doesn't it? If I offer to sell my phone to a man in the pub, an oral contract's probably okay. If I'm offering to sell my house to someone, I imagine an oral contract, although it might start that way, you're going to want a written acceptance, aren't you? You're not going to sell your house based on some oral agreement, unlikely anyway. And then the third method is by a person's conduct. Yeah. So you could accept the terms by performing an act in what's known as a reward case. So if someone said, for example, my offer is to pay you £100 for a day's work. If you turned up and did it, you may not have said you're actually going to do it. You hadn't put it in writing, but if you turned up and actually worked, then is that not you accepting the terms? I would say it probably is. So your conduct probably infers that you have accepted the offer. A little bit in the bottom right corner of the slide there about communication. So email and faxes. So if you were to communicate by email or fax, they are effective when they arrive at the recipient during business hours. So they are considered to, you are considered to have accepted at the point, email or fax was received, if received during business hours. If received outside of business hours, it's when the business next opens. That's the legal standpoint there. Yeah. It's a bit of a worked example here then. So what we've got is a scenario. Simon agrees to sell his car to Tony for £600. And Tony asks if he can decide by 9 o'clock tomorrow morning. Simon agrees to that. And then that evening, Tony's friend Rick, who it says there is reliable, tells him that Simon's decided to keep the car. Is that valid revocation of the offer? So this is interesting here, is that it is, because revocation of an offer can be communicated by a reliable third party. Yeah, so if you think about that's one example, but if you think about a more real world example, if I was to sell a house, I've probably got an estate agent involved. Yeah. And the offers could be rejected by the estate agent on my behalf. Yeah, and communicated by them. So I don't necessarily have to communicate with the potential buyer of my house that I've rejected the offer. That communication could be by a reliable third party, in this case, an estate agent. Yeah. So as it says, Simon is not bound to keep the offer open just because he said he would, unless Tony pays to keep it open. He pays some fee to keep an option to buy the car, which is not done in this case. Next element then is this thing called consideration. Now, definition of consideration, it's the price that one party pays for the other's promise. So if you think about the average contract, somebody's going to give something and somebody's going to take something. Yeah. So I give my money to BMW to buy a car. Yeah. So I give money, they take my money equally. Yeah. They give me a car and take my money. So on both sides is give and take. So contracts require this concept of quid pro quo. Yeah. It's ultimately something for something. Yeah. So it's give and take. So I give my money, take their car. They give me their car and take my money. Yeah. So we have two types of consideration then. We have what's known as executed consideration, which is provided at the time of the agreement. So imagine that I do agree to buy a car. So we agree to buy a car, we make an offer, offer's accepted, walk into the dealership and pay some money. I was going to say drop some cash on the table, but can't do that anymore. It's anti-money laundering. We'll have to bank transfer it. But it's provided at the time of the agreement. Yeah. Another option might be what is known as executionary consideration, which is a promise to do something in the future. Yeah. So that might be, I'll pay a deposit today. Yeah, and you promise to provide some service in the future. Yeah. Or I'll provide the service today and you agree to pay for it in the future. Yeah. So I'm ultimately giving you credit of some sort. So I'll provide it today and you pay for it later. It's a promise for one party in this contract to do something in the future, like pay or provide some goods or service. Now, another thing that's really important to understand when it comes to consideration is that consideration legally must have some value. Yeah, so it needs to be what's known legally as sufficient. However, it does not need to be a fair swap. Yeah, so it doesn't need to be adequate consideration. So in theory, you could sell your house for £1. Yeah. So the consideration you're getting, £1, that has some value. It is sufficient to be consideration. It is not a fair swap, though, is it? It's not adequate. Yeah. Giving £1 for £250,000, £300,000 house is not a fair swap. So it's not adequate, but it is sufficient. So there's an example there of a case, Chappell & Co. versus Nestle. So in 1960, so Nestle offered a bunch of vinyl records in exchange for a small amount of money and some chocolate wrappers. And the court ruled that the wrappers were valid consideration, even though Nestle threw them in the bin. Yeah, because those chocolate wrappers had some value. Yeah, so sufficient consideration does not need to be a fair swap. So you have no real, they're not adequate consideration. Chocolate wrappers for records is not adequate, but it does have some value. So as it says there, the court would not protect you from a bad bargain. £1 per house is valid. Yeah, that is valid consideration. By no way is it adequate, but it is sufficient in law. Yeah. So what is invalid consideration then? So we understand what valid consideration is. What is invalid consideration? So bunch of things here. Past consideration. So you cannot use an act already performed as consideration for a new promise. So you can't say, oh, well, I gave you £10,000 last year, so it's okay. No, because that's consideration for a past event. It's not related to a current promise. There is a case, McCardle case, which I'll post some links to some of these cases, so people who are interested, they can read them. Also, vague promises. So I promise this to my mum all the time. I promise to be a good son. Well, guess what? That's too vague to have any value in law. Just a vague promise. Yeah. It's not valid consideration. It's too vague. Yeah. And invalid consideration is also an existing legal duty. Doing what you're already legally required to do is not new consideration. Yeah, so example at the bottom, quite a real world example. If you find a wallet, so you're in, I don't know, you're in the local town centre and you find a wallet on the floor and you return it. And the owner later promises you £10. Well, guess what? You can't sue for £10 because your act was in the past. Yeah, you give it him back, and then he said after, "Oh, I'll give you £10 for it," but your act was already performed. So so that's past consideration. Yeah, you gave him his wallet back, and then he later said, "I'll give you £10." If he didn't give you the £10, you wouldn't be able to sue him. Yeah, because your side of that contract, yeah, was in the past. Very much not something you'd be able to sue for. Not sure you would anyway, but a couple of scenarios then around valid consideration. So, scenario one, paying £1 rent per year for a large house. So a couple of examples of people that have done this. So Andrew Mountbatten, Windsor. He had the Royal Lodge in Windsor. It's rumour, of course, that he paid £1 in rent to the Crown Estate. He probably did, but that's the rumour. The important thing there is that would be valid consideration. Yeah, because £1 has a value, it's sufficient in law, but not adequate. Again, there's a piece of case law there that I will provide some links to. Returning a lost cat before the reward was offered. So you give the cat back, and then they said, "Oh, I'll tell you what, we'll give you a reward." Well, you gave them the cat back before the reward was offered. So therefore, if they didn't pay you, you wouldn't be able to do anything because it's invalid, it's past consideration. Trading a rare stamp for a bag of sugar. Valid, because the rare stamp has identifiable value, of course, and a bag of sugar that has identifiable value as well. So again, it's sufficient, but most definitely not adequate, but is valid. Bottom one, agreeing to be nice to your business partner. Well, guess what? It's invalid because it's too vague, massively uncertain. Can't. It has no, it's too vague. How do you value being nice to your business partner? What's the financial value of that? Can't really quantify it, can you? So we've now got a contract, and we've agreed. An offer's been made. We've agreed the offer. Both sides have given up some level of consideration, and we've got a contract. Yeah, so we've got a very valid contract, and then all of a sudden somebody doesn't do what they should do. So, got a contract with a builder to build a house, and I paid, and he doesn't build the house. Yeah, what do we do? So, breach of contract. Yeah, it's what happens if one side of this contract doesn't perform the promise that's defined in the contract. So they don't hold their side of the bargain, essentially. What do we do? Well, a couple of options. There are different types of breaches to start with. Yeah. So there are what are known as actual breaches, and then anticipatory breaches. So the stuff at the top of the slide. So an actual breach is the failure to perform when the duty is due. So one party fails to show up, or performance is fundamentally inadequate. So imagine we've got a contract with a builder to build a house. Yeah. If we say the house needs to be built by the end of May, and on the 1st of June, it's not been built, well, you've actually breached the contract. Yeah. One party has failed to provide what they should have provided in that contract. Yeah, it's an actual breach. It's actually happened. Yeah. The other example, the other type of breach is what's known as an anticipatory breach. So before the due date on which they're supposed to perform their duties under the contract, they tell you they're not going to do it. Yep. So they state before the due date that they will not be performing whatever their promise is under the contract. So that's the builder telling me that we're not doing it. Yep. So we're not going to build your house, Dean. Yep. But it's not. But the contract says we've got to build it by the end of May. Today's the 1st of May, but we're telling you right now we're not going to be able to do it, or we're not doing it. So that's an anticipatory breach. Now you get two types of anticipatory breach. The express anticipatory breach, which, as it says at the bottom, explicitly telling the other party, I ain't doing that work next week. Yep. So I'm not going to come and build your house, Dean. I ain't got time. I'm doing something else. I'm on holiday on a beach in some nice hot country in the world. Yeah. But either way, I've told you, yeah, and I've expressed in words that I'm not doing it. Yeah. So that's an express anticipatory breach. The other type of anticipatory breach is what's known as an implied anticipatory breach. Yeah. So what this is acting in a way that makes the performance impossible. So it could be that I've got a contract to build a house by the end of May, and the builder decides to take everybody off my building site and start working on some other building site down the road. Now, he hasn't told me, hasn't explicitly told me that my house won't be built, but he's acting in a way that makes the performance impossible. There's no one building at my house. They've got another 2 weeks to do it, and there's no one there doing it. Chances are it's not going to get done. So it's implied by their conduct, it's implied that they are going to breach the contract. Yeah. So actual breaches, they've actually breached the contract. Anticipatory breach, we anticipate they'll breach the contract. Express, they've told you. Implied, conduct implies that they're going to breach the contract. So what can you do? So what are your options if you are involved in a contract and one side of that breaches the contract and you're left out of pocket potentially? Yeah. So my builders decided they're not building my house. I paid them a load of money. What can I do about it? Well, there's some rules called the Hadley and Baxendale rules, which again I'll provide a link to. But it talks about damages. Yeah, so physical, monetary damages. In order to be able to claim damages, however, loss can't be what's known as too remote. Yeah. So we have what are known as normal losses and what are known as abnormal losses. So normal losses are the losses that arise naturally as a result of the breach. So if my house is not built, then my losses are ultimately the money I paid for my house to be built. Yeah. Abnormal losses only if that was understood, contemplated and understood by both parties at the time of the contract. Yeah. So if we had a contract, I don't know, let's say we had a contract to build a music venue, yeah, and that music venue was then going to be used to host a Take That concert. Yeah. So the music venue, so we've got a contract with a builder to build a music venue. Yeah. And the music venue didn't get built. Well, we'd be able to sue, wouldn't we, for normal losses related to the fact the music venue wasn't built, i.e. we'd be able to get our money back. Yeah, and possibly some damages, all that. However, unless we made the builder aware of the fact that this needs to be built by this day, because we need going to use this venue for Take That concert and that delivers all of this revenue, we won't be able to sue for what's known as abnormal losses because they are not aware. So we can only sue for abnormal losses if both parties were aware at the time of the contract that building that music venue is required in order to be able to satisfy this commercial deal we've got down the road here with Take That to hold a music concert that's going to deliver £1 million of revenue. Yeah. So that is argued in law to be too remote a damages unless both parties were aware at the time the initial contract was drawn up. Liquidated and penalty clauses then. So this is quite an interesting element of the contract law section of the unit. The difference between what are known as liquidated damages and penalty clauses. So liquidated damages. So in your contracts, you may have some provision for damages. So if you don't do what you say you're going to do, you need to pay this amount of money to the customer, for argument's sake. Yeah. So liquidated damages are, in law, a genuine, and that's the key word, a genuine pre-estimate of the loss. Yeah. So if you don't build my house, this is a genuine estimate of what my loss looks like. If you build half my house, this is what the loss looks like. If you don't do any of it, that's what the loss looks like. Very much an actual estimate of the loss. Yeah. The thing with liquidated damages is they are enforceable by a court. So a court will enforce, a proper genuine pre-estimate of the loss. What they won't enforce in a court are things that are called penalty clauses, yeah, which are excessive or arbitrary sums meant to punish people. Because that is not what liquidated damages are. Liquidated damages are supposed to put the injured party back in the position they would be in had the contract been performed the way it should have been. Penalty clauses are there to punish people. Yeah, so a penalty clause, for example, is I want you to build an extension on my office. I want it done by Friday. If it's not done by Friday, there's £1,000 per day until it's done. Well, that's just an arbitrary sum, isn't it? £1,000 a day. It takes no account of how much work you may or may not have done. Doesn't take any account of, you may be very close to finishing the job on Friday, or you might not have even started it. But we're just going to charge you £1,000 a day until it's actually done. That's an arbitrary sum. Equally, we might say use something like HS2 rail project as an example. We could say to major contractor on HS2, it's got to be completed by the end of 2028, and if it's not, there's a £10 million penalty. Well, that could be excessive, right? They could nearly have done it. Yeah, but either way, it's definitely an arbitrary sum and it's potentially excessive. It's penalty clauses are meant to punish people, therefore not enforceable in law. Yeah. So there is a case, Ford versus Armstrong. Ford, as in Ford Motor Company. Armstrong, a dealer that were selling Ford cars. And what they were saying is there was a penalty. Ford enforced, this was a good number of years ago. Ford enforced or tried to put in the contract that they were going to charge a penalty of £100 for every car sold at less than list price. And the courts found in favour of Armstrong and said that that was a penalty clause, therefore not enforceable in law, because you could have sold the car for £1 less than list price, or you could have sold the car for thousands of pounds less than list price, and you were getting the same arbitrary penalty. So it's not liquidated damages because it's not a genuine pre-estimate of the loss. It was just an arbitrary sum meant to punish people. So not enforceable in law. Yeah. So the example, using the same amount for both tiny and huge breaches is a sign of a penalty clause. And as I say, not enforceable. Other options then in terms of remedies for breach of contract. So we mentioned damages. Damages are probably the most common remedy for breach of contract, but not the only one. So it depends what you've done, right? And it depends. Sometimes damages are not the right option. So, for example, if we are Samsung, let's say we're Samsung, yeah, and believe it or not, in the Apple iPhone, there's a lot of Samsung intellectual property. Now, if Apple breached a Samsung patent, yeah, well, we could go and sue Apple for damages. We could. What would hurt them more, though? Probably an injunction stopping them from doing something, like stopping them selling phones. Yeah, that would probably hurt them more. Yeah. So we got these things known as equitable remedies. And we can, there's three. There's what's known as a specific performance remedy. Yeah, so you can go to court and the court could order the party to fulfill the contract. Now, not available for personal services contracts, but what we're trying to do there is we're trying to enforce the positive aspects of the contract. Yeah, so we're trying to give the person who's been breached, we're trying to put them in a position that they would be in had the contract not been breached. Yeah, so specific performance clause, for example, house builder. So I'm the customer, I wanted my house building, the house builder didn't build it. Could go to court and we could get a specific performance remedy that says you must build that house. Yeah. That puts me, the injured party, in a position that I would be in had the contract been executed in the way it should have been before a breach of contract. The second option is what's known as an injunction. So the court could order a party not to do something. Yeah. So we could say you can't sell phones. Yeah. You can't sell certain phones. You can't trade within certain geographical area. You can't use that company name because it's too similar to another registered company. Injunctions, stopping people from doing things. Yeah. And then the final equitable remedy is this thing called rescission, which puts both parties back in the exact position before the contract started. Now, depends on what you're doing. Yeah, because the true definition of that is if, let's say, we're building a house and it's half built, putting parties back in their exact position before the contract means taking the house down. Yeah, taking the whole house down and putting the whole site back how it was before we even started, which might not be possible. Yeah. In some cases, rescission is the option. Yeah. If I've give up some money, for example, for a service I've never received, yeah, rescission just gives me my money back, does it not? Yeah. Puts us both in the exact same position we'd be in before. They don't have the money and I have it back. It depends on what the contract is for. Like I say, I've seen different options, different of those equitable remedies work in different cases. The injunctions are really powerful in some cases, because by stopping someone from doing something, you're taking their revenue stream away in some cases, which can be that can get them to the table to come up with a proper solution quite quickly.